Listen, your business might be brilliant, your idea, genius, but if your shareholder agreement is garbage, your company is a ticking time bomb. I've seen it too many times. Two best friends go into business together, one gets greedy, and boom, the whole thing collapses. And guess what caused it? A shady clause buried in the shareholder agreement that nobody read carefully. I'm Santiago Cueto, a board-certified international attorney, and today I'm exposing the top red flags hiding in your shareholder agreements that can destroy your company in Florida and how to fix them before it's too late. Let's jump in. You might have already signed your agreement. Maybe you're drafting one right now. But these are the red flags you cannot afford to ignore. Red flag number 1, no restrictions on share transfers. What happens if your partner wants to sell their shares to your competitor? Without a right of refusal clause, you could wake up one day and be in business with a total stranger. That's how hostile takeovers happen, even in small companies. Red flag number 2, equal ownership with no tiebreaker. Let's say there are two shareholders, each with 50%. Sounds fair, right? Until there's a disagreement and you're stuck in a deadlock. Without a deadlock resolution clause, you could be heading to court just to settle internal arguments. Red flag number 3, no defined exit strategy. If there's no buy-sell clause or valuation method in place, exiting the company becomes a nightmare. You don't want a departing shareholder dictating terms on their way out. That's like letting someone burn down the house after they've moved out. Here's where it gets sneaky, and Florida business owners get trapped. Red flag number 4, unequal voting rights without protection. Sometimes founders bring in investors who get preferred shares. That's fine until those shares come with voting rights that override your own. If your agreement doesn't protect your role as a decision maker, you could be ousted from the company you built. Red flag number 5, no clear role definitions. Are shareholders also directors, officers? Are they expected to work or just invest? If that's not crystal clear, someone's going to coast while the others do all the work, and that resentment will explode eventually. And red flag number 6, no non-compete or confidentiality clause. This one hurts. I've seen shareholders leave a company and start an identical business down the block because no one included a non-compete. In Florida, these clauses must be reasonable to be enforceable, but you better have that. Otherwise, your secrets walk right out the door. I'll give you a real story. A tech company here in South Florida bought me in after a shareholder left and launched a copycat app, stealing clients, stealing talent, even stealing code. Why? Because the original shareholder agreement had 0 protections, no IP assignment, no non-solicit, no exit plan. We had to scramble just to get back control. Don't make the same mistake. And the worst part? It was preventable with just a few extra paragraphs in the original agreement. Look, your shareholder agreement is not just a formality, it's your company's constitution. One bad clause can cost you everything. So before you sign, do this. Get it reviewed by an experienced business attorney. Make sure it includes transfer restrictions, exit plans, voting roles, and IP protections. And if any of the red flags I just shared sound familiar, fix them now. If this video opened your eyes, hit that like button and subscribe. We break down real business law like no one else.